Hello and welcome back. You're listening to the WeCyberYou Unlocked podcast. And I have to say, I am genuinely excited for today's session.
I am too, even though, I know usually when people hear about acts and legislation, their eyes kind of just glaze over immediately.
Oh, yeah, absolutely. They reach for the skip button or they just assume it's a problem for the legal department to handle. But today, we are doing a deep dive into something that is effectively the constitution of your digital life. We are talking about POPIA.
The Protection of Personal Information Act. And you're completely right about that initial reaction. It sounds heavy, it sounds bureaucratic, but it is actually one of the most significant pieces of legislation affecting every single person with a smartphone or an internet connection in South Africa.
It really is. And before we get into the weeds, and trust me, the weeds are really fascinating today, I want to give a massive shout out to the team that made this deep dive possible. All of today's insights, the breakdown of the legal text, all the source materials are provided by WeCyberYou.
Which is fantastic, because legal texts can be, they can be incredibly dense. Having a reliable source like WeCyberYou to just distill it down into plain English is essential. They've done the heavy lifting so we can actually have the fun conversation.
Absolutely. So let's unpack this. When I think of a privacy act, I usually just think of those, those annoying pop-ups on websites that I click accept on without actually reading.
Yeah, the cookie banners.
Right, the cookie banners.
Yeah.
But this feels different. What is the actual mission here? I mean, is it just red tape?
It is definitely not just red tape. You should really think of POPIA not as a barrier, but as a framework for trust. It is South Africa's main privacy and data protection law. Its mission is to regulate the entire life cycle of data.
The whole life cycle.
Yeah, exactly. We were talking about how personal information is collected, processed, stored, shared, and eventually protected.
So it's basically the rule book for the digital age.
In a way, yes. It gives individuals actual rights over their own data. And crucially, it holds organizations accountable if they misuse that data.
That is the key word, isn't it? Accountability. Because, let's be honest, in this digital world, we are handing over data constantly.
Every single day.
Right. Every time I sign up for an app, every time I buy something online, I kind of feel like I'm throwing pieces of my identity into a black hole.
That's a very common feeling. In the industry, we call it data resignation. You just assume you have no choice.
Yeah, exactly.
But POPIA exists to ensure that the black hole actually has rules. It ensures that organizations act responsibly in a connected world. It's really about shifting the power dynamic back to you, the consumer.
Okay, so we know what it is. It's the shield for our digital lives. But let's get into the specifics. Who is actually under the microscope here? Like, who has to follow these rules? I assume the big banks, the telcos, the tech giants.
Oh, it goes much further than that. According to the source material from WeCyberYou, the scope includes all public and private organizations within South Africa.
Oh, all of them. Even the really small guys.
All of them. If they process personal information, they are on the hook. That means your local municipality, the grocery store down the street running a loyalty program, your insurance company, and yes, the massive tech conglomerates too.
Wow.
Size doesn't really matter here. The data matters.
So public and private. That covers basically everyone doing business or running a service in the country.
It does. But here's where it gets really interesting, and this is a nuance that people often miss in the fine print. It isn't just restricted to organizations physically located here.
Really?
Yeah, the source highlights that even foreign organizations must comply if they process the data of South African residents.
Wait, hold on. Let me get this straight. So if a company is based in, say, California or London, but they are dealing with my data here in South Africa, they have to follow POPIA.
That is exactly right.
Yeah.
If they are processing the data of South African residents, they fall under the scope.
That is huge. It basically means we are exporting our privacy standards. It's a global standard applied locally.
That's a really great way to put it. It acknowledges that the internet doesn't really have borders. If you are touching the data of people here, you've got to play by the rules here. It prevents companies from just setting up shop in some data haven with weak laws just to avoid responsibility. It levels the playing field.
That makes a lot of sense. It stops the arbitrage of privacy. Okay, so we know who has to follow the rules. Now let's talk about the what. The act is called the Protection of Personal Information Act. But what actually counts as personal information?
Well, you might think it's just the basics, right?
Yeah, like my name, my email address, the stuff I put on a business card.
And that is certainly part of it. But the source from WeCyberYou goes much, much deeper. It defines personal information as literally any data that can identify a person.
Any data. That sounds intentionally broad.
It is. The list breaks it down into a few categories to really help us understand the scope. First, you have your contact and ID info. Names, phone numbers, addresses, email addresses.
Right, the standard stuff.
Correct. But then you move into what I like to call life data. This includes your financial history, your health records, your educational background, and your employment information.
Oof. That's the stuff you really don't want leaking out. I mean, health records and financial history, that is incredibly private. That tells a whole story of your life.
Exactly. If someone has that, they don't just know who you are, they know how you are. And then there is the category that really highlights the modern nature of this act: digital identity. The source specifically mentions online identifiers.
What does that include?
Things like IP addresses, location tags, and device data.
Whoa. So my computer's IP address counts as personal information.
If it can be used to identify you, yes. And in many, many cases, it can. It links your digital behavior back to a specific location or person. It shows that the law understands that we leave digital footprints that are just as distinct as our physical ones.
That is fascinating. So it's not just about who I say I am, it's about what my device says I am.
Spot on. And we aren't even done yet. There is another layer called sensitive information, or, as it's called in the legislation, special personal information.
Well, this sounds serious.
It is very serious. The Act creates a special category for things like race, religion, trade union membership, and biometric data.
Biometrics. So like using my fingerprint to unlock my phone?
Yeah.
Or facial recognition?
Exactly. That data is considered sensitive because it is immutable. You can change your password. You can even change your name legally if you really wanted to.
Sure.
But you cannot change your fingerprint. You cannot change your retina. If that data is compromised, the risk is significantly higher because you can't just reset your biology.
That is a chilling thought, but I'm really glad the law recognizes that distinction. So the takeaway here is that almost anything that points back to me falls under this umbrella.
That's the best way to think about it. If it points to a specific human being, it's personal information and it needs to be protected.
Okay, so we have the players, basically every organization. We have the data, basically everything about us. Now let's talk about the rules of the game. The source outlines specific principles that organizations must follow when they handle this stuff.
Right. These are the core principles of processing. There are 6 of them mentioned in the text, and they really form the framework of responsibility.
Let's run through them, because I feel like this is where the rubber meets the road. This is what companies actually have to do day to day.
Principles 1 and 2 are foundational: fairness and purpose. The source says data must be processed lawfully and fairly. That seems obvious, but it means you can't use deception to get data.
So no tricking people into handing over their info. No fake contests.
Right. Transparency is key. And closely tied to that is the second principle. It must be collected for a specific purpose.
Specific purpose, meaning they can't just vacuum up data just in case they might need it later.
Exactly. You can't hoard data for a rainy day. You have to know why you are collecting it at the exact moment you collect it. If you are collecting an email address just to send a digital receipt, you can't simply decide 6 months later to sell it to a marketing firm. That wasn't the specific purpose.
I love that. It stops the data hoarding. Which leads us nicely into the third principle, which I think is my favorite because it feels most practical. Minimization.
Yes. The source phrases this as data must be adequate, relevant, and not excessive.
Not excessive. I feel like I need to print that out and mail it to some companies.
Hmm.
When you're trying to sign up for a simple email newsletter and they ask for your home address, your phone number, and your date of birth.
And you sit there thinking, why do you possibly need this?
Exactly. I'm like, you don't need my shoe size to send me a weekly update.
That is a perfect example of violating the minimization principle. If they don't need the shoe size to deliver the newsletter, they shouldn't be asking for it. They should only collect the absolute minimum amount of data necessary to get the job done. It's about data hygiene.
It's about respecting the user's boundaries, too. And honestly, it protects the company as well. Less data means less liability.
That is a very smart way to look at it. Then we have principle 4, which is accuracy. Data must be accurate and up to date.
This one seems tough for companies. I mean, people move, they change names, they change banks.
It is a challenge, for sure, but it's a requirement. Organizations have to take reasonably practicable steps to ensure the data isn't stale or incorrect. Imagine if a credit bureau has the wrong financial data on you. That could ruin your ability to get a home loan. Accuracy is critical for fairness.
That's a really high-stakes example. I can totally see why that's a law. What about when they are done with the data?
That's principle 5, retention. Think of it as the expiration date.
I like that. Data has a shelf life.
It does. The source says data should be kept only as long as needed. Once the purpose is fulfilled, going back to that specific purpose principle we talked about, you should delete it. You don't just keep it forever.
So if I cancel my subscription to a service, and 5 years later, they still have my credit card info and home address on file, that's a no-no.
Unless there is a very specific legal reason to keep it, like tax laws requiring record keeping, yes, that would likely violate the retention principle. They shouldn't be holding on to it indefinitely just because they forgot to delete it or couldn't be bothered.
And finally, principle 6. The one we all worry about when we hear about hacks in the news.
Security. The data must be protected with appropriate security safeguards.
Appropriate is an interesting word there. It sounds a bit vague.
It is, but legally it's very specific. It means the security has to match the sensitivity of the data. If you are storing medical records, your security needs to be Fort Knox. If you are storing a list of favorite ice cream flavors, maybe it doesn't need quite the same military-grade encryption, but it still needs to be secure.
Right. It prevents negligence. You can't just leave the files on a USB stick in a little coffee shop.
Exactly. So when you synthesize all these fairness, purpose, minimization, accuracy, retention, and security, you see that companies can't just be cowboys with our data anymore. They can't hoard it, they can't be careless with it, and they can't use it for things we didn't explicitly agree to.
It sounds like a massive shift in power. For a really long time, it felt like companies held all the cards, they had the data, they made the rules.
Yeah.
But listening to this, I'm wondering, where does this leave the regular person? Where does this leave you and me, the listeners?
It leaves us in a much stronger position. This brings us to the section on the rights of the individual. POPIA isn't just a list of chores for companies, it's a bill of rights for people.
So what can I actually do? What rights do I have right now?
Well, based on the source material, you have several powerful tools. First, you have the right of access.
That means I can ask to see what they have on me?
Yes. You can go to an organization and say, show me the personal information you hold about me. And they have to comply. They have to tell you what they have.
That is transparency in action.
It is. Then you have the right of correction. If you use your access right and see that they have your address wrong, or maybe your name is spelled incorrectly, you have the right to request updates or fixes.
Which ties right back to the accuracy principle we just talked about.
It's a full circle. Then you have the right to transparency. This means the right to be informed about how your data is processed. They can't just say, oh, we're processing it. You have a right to understand the actual mechanism.
No secret algorithms deciding my fate without me knowing the basics.
That's the idea. And if you don't like what you hear, you have the right of objection. You can object to certain processing activities.
So I can say, I'm okay with you having my email for the receipt, but I object to you using it for analytics.
In many cases, yes, if you have reasonable grounds. And perhaps the most powerful right of all is withdrawal. The expert material emphasizes the right to withdraw consent for data processing.
The ultimate opt-out.
The ultimate opt-out. If you gave consent previously, you can take it back. You can say, I've changed my mind. Stop.
That is really empowering. It really makes you feel like you own your digital self, rather than just renting space on someone else's server.
That's the entire goal, to restore ownership to the data subject.
And there is always a but, right? Rules are only as good as the referee. I mean, who is actually watching these companies? If a giant corporation decides to just ignore my request to withdraw consent, who am I going to call?
You aren't going to call the Ghostbusters. You're going to look to the information regulator.
The information regulator. That sounds very official.
It is. They are the watchdog. The source identifies them as the statutory body that enforces these rules.
And do they actually have teeth? Or is it just a slap on the wrist?
Oh, they definitely have teeth. The consequences for non-compliance are significant.
What kind of consequences are we talking about here?
We are talking about fines, heavy administrative sanctions that can easily run into the millions, and it doesn't stop there. The source also mentions civil claims.
So I, as a regular person, could sue.
If you have suffered damages due to non-compliance, yes, civil claims are definitely on the table. But there is another consequence mentioned in the WeCyberYou material that might be even scarier for businesses than a fine.
What's that?
Reputation. The source notes that serious data breaches can severely damage a reputation.
Oh, absolutely. Trust takes years to build and seconds to break. If I hear a bank or a hospital played fast and loose with my data, I'm gone. I'm switching providers immediately.
That reputational damage can be fatal to a business. So the why for compliance isn't just about avoiding a fine. It's about survival. It's about maintaining the trust of your customers.
That leads me to the bigger picture. We've talked about the individual and the company, but why does this matter on a macro scale? Why does South Africa need this law right now? Is it just to make us feel better?
No, it's much more strategic than that. If we zoom out, it's about creating a culture of responsibility. The source mentions that this impacts businesses, schools, social media platforms, healthcare providers, and even AI services.
AI services, that is huge right now. Everyone's talking about artificial intelligence.
It is. As we integrate more AI, the data hunger just grows. AI needs data to learn. POPIA ensures that this growth happens responsibly so we don't end up in some dystopian surveillance state. But there is also a purely economic angle here.
Economics. How does privacy help the economy?
Through global trade. The expert analysis explains that POPIA aligns South Africa with international privacy standards.
Ah, I see. So it's about being part of the global club.
It is. Think about the European Union. They have the GDPR, which is famously very strict. They are not going to allow their businesses to send data to a country that doesn't protect it. By having POPIA, South Africa signals to the world, hey, your data is safe with us.
So it actually facilitates business. It's not a roadblock, it's a bridge.
That's the perfect analogy. It's a bridge built on trust. International partners can trust the data handling here, which opens doors for South African businesses to actually compete globally. It means a startup in Cape Town can handle data for a client in Berlin because the legal frameworks are compatible.
Wow. So what does this all mean? Let's recap. We went from thinking this was just boring paperwork to realizing it's actually the foundation of our digital rights, a safeguard against AI misuse, and basically a key to our economic future.
It's about accountability, security, and ultimately giving power back to you, the individual, regarding your digital identity. It turns us from passive data sources into active participants with real rights.
Active participants. I love that phrasing. It forces us to wake up and take the wheel.
It really does.
Listeners, this has been a fascinating journey through the Protection of Personal Information Act. I hope you feel a little more empowered about your own data today and a little less intimidated by all the legalese.
Knowledge is always the best defense.
It certainly is. And remember, this was the WeCyberYou Unlocked podcast. If you enjoyed this deep dive and want to stay smart about your digital life, please make sure to follow the channel. And for more educational cybersecurity content like this, head over to WeCyberYou.com.
Definitely check that out. The resources they have are incredibly valuable for both businesses and individuals.
Before we go, we always like to leave you with something to think about. We've talked about rights, we've talked about laws, but here is where it gets really interesting.
Indeed. We discussed how POPIA is required for global trade. We essentially said that if a country has good privacy laws, it gets to participate in the global economy.
Right. It's the ticket to ride.
So if POPIA is required for global trade and international standards, does that mean data privacy is no longer just a personal right, but a currency for economic survival?
That is a heavy thought. Is your privacy now a tradable asset, an actual currency?
It makes you wonder, if data is the new oil, then privacy laws are the trade agreements that let the oil flow.
Mull that over, everyone. Is privacy a product? Thanks for listening, and we'll catch you in the next deep dive.
Goodbye, everyone. Stay safe out there.